Now we will read Article 14 of Indian Constitution. And Article 14 is part of right to equality. Under right to equality, 5 articles are there, and those are Article 14 to Article 18. So we will read now Article 14. And what Article 14 is saying is that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So Article 14 states that state shall not deny to any person equality before law or equal protection of laws within the territory of India. Now the question is, what is the state? So we have already read that the state is defined under Article 12, and that we have already discussed. Now let's continue. So state shall not deny to any person. Any person. Here this word is important. Any person here means Article 14 is applicable to citizen as well as to foreigners. That means it is saying to any person. Any person includes citizens as well as foreigners. So state is defined in Article 12. Any person means both citizens and foreigners. And there are two terms. One is this one, equality before law, and another one is equal protection of law. We will understand both of them one by one. Before that, I will tell you one thing, that this concept equality before law is a negative concept, and this concept is taken from UK, and equal protection of laws is a positive concept, and this is taken from US. Now we will understand the concept equality before law. What is the meaning of equality before law? One meaning is that absence of any special privileges in favor of any person. So absence of special privileges in favor of any person. This is one thing. Then another thing is that we can say the equal subjection of all persons to the ordinary law of the land. So equal subjection of all persons to the ordinary law of the land. And then another thing that we can say is part of equality before law is that no person is above the law. So equality before law means there will be absence of special privileges in favor of any person, then equal subjection of all person to the ordinary law of the land, and no person is above the law. So this is equality before law. Now this equality before law, this concept is part of rule of law concept that was given by British constitutional expert A.V. Dicey. So A.V. Dicey's rule of law. So equality before law is part of this rule of law given by British constitutional expert A.V. Dicey. Now this concept equality before law, or let's say fundamental rights under Article 14, is not absolute. That means there will be some exceptions. Now let's read the exceptions of equality before law. Now this exception is given to president and to governor. So this exception is given to president, or let's say governor. And what kind of exceptions are available to president and governor? Let's assume when the president or governor is discharging his or her official functions, then when they are discharging their official functions, for the discharge of their official functions, president or governor is not answerable in the court of law. So not answerable to court of law for what? With regard to discharge of their official functions. That means president and governor, they are not answerable to the court of law for their official discharge of functions. So this is one exception of equality before law. Then what are the other exceptions? Other exception is that for president and governor is that no criminal action, no criminal proceedings can be initiated against them so long as they remain in office. So when they are in office, when they remain in office, that time no criminal action can be initiated against them, either president or governor. So two exceptions here I am talking about. One is that the president and governor, they are not answerable to the court of law with regard to the discharge of their official function, and another is that no criminal action can be initiated against president, against governor, as long as they remain in office. Then another exception if I talk about, then this is applicable to foreign diplomats. So foreign diplomats are not answerable to the court of India while discharging their official functions. So these are some exceptions under equality before law. Now we will read equal protection of laws, which is a positive concept, and this is a concept taken from United States of America. Now let's understand this concept. Now let's take one example. Suppose there is a person who is adult, and this person has committed murder. And suppose there is another child. There is a child who by mistake has committed a murder. Now by mistake means, suppose let's assume that this child somehow got a gun and that child fired that gun, and by that way, by mistake, this child has committed murder. Now when there is a person who is an adult, that person is committing murder, and for that suppose we are giving him capital punishment. But should that capital punishment also be given to this child? This is the question, because then equality before law is saying when a murder has been committed, the punishment should be death, capital punishment. But should we, now the question arises, should we also give this child who has done the murder by mistake the capital punishment? Because this person here who is adult is not doing the murder by mistake. This person is committing murder knowingly, and this person knows the consequence of murder. He knows that when he will be caught, he will be put to death. But this child by mistake has committed murder. That means what I am asking you, that should we treat all persons equally blindly? So the answer comes out to be no. That means we should treat people, those who are in similar situation. That means like should be treated alike. That means those who are in similar situation, they should be treated equally. Now let's take another example. Suppose there is a person whose income is 5 lakh per annum, and suppose there is another person whose income is 1 crore per annum. Now should the government impose same tax on both of them? So if we apply equality before law, then the person who is earning 5 lakh and the person who is earning 1 crore should be impose the same tax. But here in India we follow progressive taxation. That means according to your income, the government will impose the income tax. So this is nothing but equal protection of laws. That means equal protection of laws is saying that we will treat all the people equally, but only if those people are in similar situation. That means though we will treat the like, that means the like should be treated alike without any discrimination. That means the people who are in similar situation, they should be treated equally. So this is equal protection of laws. So that means equal protection of laws is obviously talking about equality, but it is talking about equality plus justice. That means it is talking about affirmative action by the state. That means it is the affirmative action by the state towards unequal by providing facilities and opportunities. And this is one of the bases of reservation system in India. That means you cannot treat all the people equally, because you have to also take into consideration the situation, whether they are in similar situation or not. Now we will read Article 15. So, as per Article 15, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. So, Article 15 is the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Now again, the state means is already defined under Article 12, and this Article 15 is applicable only to citizen. Now the fundamental rights, those are only applicable to citizens and not to the foreigners, are Article 15, Article 16, Article 19, Article 29 and Article 30. These are the fundamental rights which are only available to citizens and not to the foreigners. So Article 15 is saying the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Here the word only is important, and here religion, race, caste, sex, place of birth, you can remember it like this: RRCSP. So now what is the meaning of this word? Why this word is used? That means the state shall not discriminate on these grounds: religion, race, caste, sex, place of birth. But the state can discriminate on valid 6th ground or 7th ground. That means except these 5 grounds, state can discriminate on other grounds. For example, let's say there is a competitive examination, and for that competitive examination, suppose there is an upper limit of 28 years of age. That means if your age is 29 years, then you are not applicable, then you are not eligible to fill up the form of that examination. Then you cannot say that you are discriminated, and Article 15 says the state cannot discriminate, so I should be able to fill up the form of that examination. But no, here why the state is discriminating you? Because you are 29 years of age, and state should not discriminate you on the basis of religion, race, caste, sex, place of birth. But state obviously can discriminate you on any other valid ground except these grounds. Here the ground is age. So state cannot discriminate you on these grounds. And now you can say that we know in panchayat election, 1/3 or 33% seats are reserved for women. That means the state is discriminating on the basis of sex. That means the reservation is given in 33% seats in Panchayat for women. So this is clearly a violation of Article 15, because Article 15 is saying that the state shall not discriminate on the basis of sex, only on the basis of sex. But let me tell you, this provision of providing 33% reservation to the women is possible because this Article 15 is not absolute. There are exceptions mentioned in Article 15 itself that state can make special provisions for women and also for children. So this is exception that state, although it is saying that state shall not discriminate only on the basis of sex, but Article 15 itself is saying that there is an exception and state can make special provision for women and for children as well. Now let's discuss some other exceptions provided in Article 15. Now let's discuss another exception provided under Article 15. So Article 15 is also providing another exception, and which says that state can make special provisions for socially and educationally backward class of citizen. That means Article 15 is also providing another exception, and it is saying that the state can make special provisions for the socially and educationally backward class of citizen and also for scheduled caste and scheduled tribe. And this exception is applicable to government institute and this is applicable to private institute as well. Now whether that private institute is aided by the government or unaided does not matter. It is applicable to aided private institute, it is applicable to unaided private institute, it is applicable to government institute. That means state can make special provisions for the socially and educationally backward class of citizen, can make special provisions for scheduled caste, can make special provision for scheduled tribe, and all these things are applicable to government institute as well as to private institute, and it does not matter whether that private institute is aided by the government or unaided by the government. It is applicable to all kind of private institute and to government institute. But here one thing that you have to understand is that this is not applicable to minority educational institute. Then in 2019, through 103rd Constitutional Amendment Act, this Article 15 was amended, and now there is special provision for economically weaker section. And currently, if we see the percentage of reservation, then for OBC, for other backward class 27%, for scheduled caste this is 15%, for scheduled tribe this is 7.5%, and for economically weaker section this is 10%. So this is Article 14 and Article 15 for you.